injuries, and abuse. Across the state of Alabama, the attorneys of Hollis, Wright & Couch are here to serve you. With civil trial lawyer Josh Wright from the firm of Hollis, Wright & Couch and Alabama's 13 host David Lamb, the attorneys answer your tough legal questions straight ahead.
Hello and welcome into the attorneys. Appreciate you being with us. Our goal here every time we have one of these shows is to answer the legal questions that you have. So we try to make it easy for you. We provide the panel of experts and a way for you to get in touch with us. Throughout the program, you'll see that information. You can call, text, or email and join the conversation tonight. We're joined by Steve Couch. He's with the firm of Hollis, Wright & Couch. Steve, good to see you, sir.
Good to be back. Thanks for having me.
Now, today, we're talking about something called premises liability. And just hosting the show, I learned phrases. I don't know if it may impress folks at dinner parties. I don't know what else I could get out of premises liability.
Yeah, this is going to be a good show. I'm excited about it. What we're talking about tonight is the responsibility that property owners or managers have when they have other people come onto their premises, be it a home or business. We get a lot of calls about this. Interesting area of the law, and for this topic and this show, we've brought on Tammy Smith from Taylor & Taylor here in Birmingham. They've been around a while and are very experienced in this type of litigation. Tammy, thanks for coming on.
You're welcome. Thanks for having me.
Yep. If you would, Tammy, just let's start from the launching off point. Just the term premises liability. Help us with a definition and an overview of what we're going to be covering tonight.
Well, basically what premises liability is when you go to a place of business or when you go to someone's house and you end up becoming injured, whether or not you have a legal claim for that injury.
Okay.
And so there are different sort of situations where you would have one, and there are certain situations where you wouldn't. And so that's kind of what we're going to cover today.
Now, is there a difference if I were to slip and fall at my friend's Christmas party versus at a big box retailer? Is there a difference there in terms of liability and what I should do?
Yes, there's definitely a difference in liability. If you slip and fall at, say, a Walmart or a Starbucks or something like that, the duty that they owe you is the duty, you're a business invitee. You're an invitee at that place, and the duty that they owe you is to keep the premises reasonably safe for its reasonable purpose.
Okay.
So they also have a duty to warn if there is a known danger. They have a duty to warn you of that known danger. A really common example is if they've mopped the floor at the Walmart, right, they have a duty to put up one of those cones to show you that they've just mopped the floor and that's a danger.
Yeah, this whole body of law, or the litigation that grows out of accidents that happens on business premises or homes, etc., it grows out of the idea in Alabama law that you as a property owner or manager have a legal responsibility to treat others that come onto your property in a certain way, in a certain manner. And the law kind of separates people by classifications, and it all boils down to what are you there to do? Mm-hmm. Why are you on the premises, and what type of property are you visiting? And like Tammy said, depending on the type of business or property you're going to see and the reasons that you're there, the law is going to throw you into a couple of different categories, and that's going to dictate basically what the property owner, or rather it's going to dictate the manner in which they have to treat you.
Right. Are there pretty specific expectations? Because if I'm someplace where I'm going shopping, I'm not really expecting a minefield to try to get to as I go to the produce department. You know, I have some expectations in terms of safety and like what you're talking about. So are there some specific expectations that are reasonable that a customer can have of a commercial enterprise?
Can I?
Yeah, go.
Okay, I think it really, to answer that question, it's almost a case-by-case basis, but because it all comes down to that word reasonable. I mean,
right,
the law doesn't define what reasonable is. What's reasonable to you may not be reasonable to me, but I think that in handling these types of cases, and Tammy, tell me if you've had a different experience, I think that there are generally some community standards that everybody will end up agreeing on. For example, you can't, if somebody comes onto your business, you can't set a trap for them. You've got to keep your premises in a reasonably safe condition for them to come on and do whatever it is that they're on the business to do. If it's a Walmart, grocery store, mall, you've got to keep the floor clear so that they can have ingress, egress, walk out of there, and so that when they're shopping and looking at the stuff on their shelves, they're not going to fall off a step or in a hole or over a bucket, or you've got to not have those things. You've got to have the premises free of those. Or if they can't be free of those types of potential dangers, you've got a responsibility to warn people that they're there. So, I mean, to answer your question, are there specific expectations? Yeah. It depends on if I'm going to your house, you're coming to my house, or if we're going to the mall. I mean, what is reasonable? Everybody's got their own definition for that, but reasonably safe, I think it's one of those things that I know it when I see it,
Right.
and as do many other people.
Yeah. Tammy, you agree with that?
Yeah, I would agree, certainly. I mean, and that's the whole point of if there is a known danger on the premises in, say, a Walmart or a Starbucks or something like that, they have to warn you about that, because that's
Right.
something that they would know about that you wouldn't know about. So I think that Steve is definitely right that it's very case by case, and but it's kind of just what you would expect when you go, like you say, you're not going to expect to have booby traps set and that
Right.
sort of thing when you go to the store.
Yeah, let me try to sum up at least this part of it. The biggest question I get a lot of times is, what can I do, or can I hold property owner responsible for my injuries if I've fallen on a premises? Well, my response to that is the typical lawyer answer, which it depends. It depends on if you're what the law calls a licensee, an invitee, or a trespasser. An invitee, like we've been talking about, that's when you come on to my premises and it's going to benefit me if I'm a store owner and you're there to spend money at my place. The other one's the licensee. That's somebody who comes on to your property for their own benefit. Come to church, for example, or you're a social guest at somebody's house. There's a different duty there. And then the trespasser, that's of course somebody who's uninvited. They go onto your property. We can get specific if you want to, but the highest duty that any property owner owes somebody coming onto the property is basically not to be negligent, to act reasonable, like we've been talking about. If you're a licensee there for your own benefit, whether you come to church or a social guest, then they just have a responsibility not to wantonly or recklessly
Right.
ensnare you or trap you or hurt you or something like that. Trespasser, of course, you just can't set traps, and we can get more specific tonight, but you can't set traps for those people. And no matter what category you fall into, David, if you know somebody is on your premises and they're in trouble, they're in peril, as the law refers to it, whether it's a social guest, a business person, or a trespasser, if they're in peril, you are not supposed to do anything negligently that would increase that danger. I mean, if they're drowning in your pond back there, you can't throw stones and try to sink them or anything like that. I know it's a silly example, but it kind of makes my point.
Yeah. What is the duty owed to an invitee?
Go ahead, Tim.
Well, the duty owed to an invitee, which is what we're talking about, like if you go to a grocery store or something like that, is for them to keep their premises reasonably safe for the reason you're there.
Okay.
So, you know, like Steve was saying, to keep the walkways clear, to not create dangers, obviously, for you. They have a duty to keep it reasonable, but you have to be mindful when you're in those types of places that there are also other people, third parties, that might also create the dangers.
Yeah.
Say, you know, if I spill something on aisle 3 and someone comes and slips behind it, they're not necessarily responsible. The store's not necessarily responsible for that if it had just happened. Now, if it had been there for an hour or so, then the reasonable thing to do would be to have already cleaned up the spill. So you really have to be mindful that sometimes you're not the only invitee, and that you need to, you know, there's different levels of that.
And what can cause a fall to an invitee?
Well, several things can cause a fall. Of course, one that I hear about a lot, and I'm sure Steve does too, is slipping and falling.
Right.
Someone spilled something, someone hasn't mopped the floor properly, and you slip and fall. Curbs, I've heard, you know, people trip over curbs. Different obstructions in aisles, for example, if you're at the Dollar General store or something and they've just put boxes of merchandise out on the floor and that sort of thing that they haven't shelved properly yet, that can cause a fall. There's also a lot of instances in places where, you know, maybe they've put merchandise on shelving and maybe some of the shelving is sticking out, or they then properly put it on some sort of, you know, pallet and haven't necessarily put the pallet back where it's supposed to go in the storage. You know, this happens a lot in big box retailers where the pallets are still out there and you can trip and fall over that sort of thing.
Yeah, and I know that we've been talking a lot about what I refer to as what's on the floor. And this is we're talking about slips and falls, et cetera, but this duty to act reasonably and keep your place in a reasonably safe condition, it would also go towards not just what's on the floor, but say on the shelf, you can't have items sticking out that could cut somebody or a child. If you're in one of those big box retailers, and how they have the boxes go into the ceiling in those warehouses, they've got a responsibility to put those things up there in such a fashion that they don't fall off and hit somebody in the head. So we're talking about everything from floor to ceiling.
Yeah,
that's what this show's about.
And we'll continue to do so after the break. Time for our first break. As we head to break, a reminder to you, we'd love to hear from you. You can call, text, email. That information easy to get right there on your screen. You can also find the firm of Hollis, Wright & Couch on Facebook. Search the term Hollis, Wright & Couch, or find them on Twitter at Hollis_Wright. Stay tuned. We're coming right back.
I'm Josh Wright with the law firm of Hollis, Wright & Couch, and thanks for watching The Attorneys on Alabama's 13. Now, we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to this show or related to other civil legal matters, call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family. Or simply contact us by going to alabamas13.com and click on the Attorneys link. We know your time is valuable, so thank you for spending it with us and for watching The Attorneys right here on Alabama's 13.
I didn't know that. Welcome back in to The Attorneys. The things you find out just by watching the show. We appreciate you being with us. We really love your input. About to get to some questions that we've received from you all, but your chance. Got plenty of time for you to get your question to us. You can call, text, email that question to us, and we'll do our best to get it to our panel of experts. As we went to break, we were talking quite a bit about homes and those sort of things. As we kind of discuss on the commercial side, a question here from a viewer that feels that there was a fall on a commercial premises, and they feel they're at fault, that the commercial premises is at fault. What should they do, which is more of a process, from a process standpoint?
Well, the first thing that's important to do is that you actually tell them that you've had the injury. You report the incident to the store owner or to the manager, and depending on where the accident has happened, in a lot of restaurants and places like that, they'll actually have a person who will come out and actually do an incident report, and that's for their purposes, for their insurance purposes. And if they do in fact do one of those incident reports, then it's important for you to ask, can I have a copy of that incident report?
Can I just ask you real quick, so just to try to make it clearer to understand, say you're at a restaurant, you go to the restroom, you slip and fall. Whenever you get back to your seat, or at some point, you need to make sure you don't need to leave the restaurant and say, you need to go ahead and say, kind of let them know then?
That's right. I think that's the best time, because you want to timely report the injury, and also it's important because whatever caused your injury might not necessarily be there in 30 minutes.
Yeah.
For example, if you've slipped and fallen on something, it might get cleaned up, and by the time you report it, it's not there, and so then it doesn't really mean as much. So.
Yeah, and all this notice, and I agree with Tammy, all this is contingent on if you're able. Of course, if you're hurt bad enough where you have to be taken medically somewhere, then of course that's first and foremost the priority. And many times a store owner, manager, whoever, they'll see you there and get your medical attention. That's the first thing you should do. But to the extent that you can, on the day of the accident, either you, friend, family member, whatever, if the store owner wasn't there to get you to the doctor for whatever reason, you do need to put them on notice. And like Tammy said, there will be somebody most likely to come out and do what Tammy called is an incident report. I've seen a bunch of these things come rolling through, and if you read them down the list of what a typical form incident report is, David, you'll see all the questions are geared towards what the victim did or failed to do. What type of shoes did they have on? Were they glasses? What were they carrying, pushing? What were they looking at? None of the questions ask, what did the store owner do about the curb that wasn't painted, that's covered with water? None of those questions will be there. So, candidly, what I tell people, if you're able to, when they're out there asking you questions about that incident report and they're rolling through questions, ask them questions. What have you guys done to try to correct this in the past, if anything? Something like that, and see what they say. Probably what's going to happen is they'll clam up. But, it's something good to know. Just ask them, because candidly, the next time you're going to get to ask them once they report it to their insurance company, which they always will do, the next person you'll be talking to is an insurance adjuster who, like Tammy said, yeah, there will be an incident report, but there will be a second incident report generated when an insurance adjuster calls you up and says, I need to ask you a few questions about this. They'll record the statement, and believe me, that insurance adjuster is not your advocate. What they're trying to do is get you to say something that will ultimately hurt your claim if ever you make one. So be wary of that, and I'd also say that it's important, I think, for somebody to get counsel as soon as possible, whoever it is, somebody who's experienced in handling premises liability type claims, like Tammy's firm.
Something else that's important, and this goes right into what you're talking about, is that at the time, if you're able, like you said, the insurance adjuster is not going to be your friend on down the road. So at the time, if there are any witnesses, if there's anybody there who saw what happened, who has any information about why it happened, for example, if somebody knows that mess was on the floor 15 minutes ago, and he went and he told somebody at the store, hey, somebody's going to trip and fall, there's a mess in the floor on aisle 2, and they didn't do anything about it. If those people are there at the incident at that point in time, it is extremely, extremely important to get their information, so that once you do retain counsel, you can say, oh, by the way, there was this witness and he can corroborate my story. Because like Steve said, the first thing they're going to do is ask you how new were your shoes? Did you have any tread on your shoes? What were you doing? Were you distracted? Were you talking on your cell phone? All these sorts of other things that are going to sort of make it seem like the reason you fell was because of your own negligence. So if there are witnesses, it's extremely important to get their information there if you can.
How formal does that notification have to be? Because oftentimes, especially if I ever see anything on the floor, certainly if I were to fall, I'd bring it to their attention, hey, I just slipped and fell, and by the way, the reason why, just kind of to make sure that the next person, it doesn't happen again.
That's right.
Would that serve as a notification?
Well, and that's another case-by-case situation. There's a bunch of law out there in the state of Alabama of what is notice. Now, in the context of a store owner, if the actual somebody who worked at the store, an employer or somebody on behalf of the store created the hazard, then they don't have to have notice. Now, if in order to be liable, they're liable because they created the hazard themselves. If like the example we gave earlier of is if I make a spill as a customer, then they will have to have notice before they would ever have a potential claim for some injury that a third party caused.
Yeah, and there's a distinction between, like Tammy said, whether they whether a store owner or property owner affirmatively creates the hazard, if they put the wax on the floor, if they put the stuff out there in the aisle, that's one thing. Again, you don't have to have notice. The other type law that you deal with is those situations like Tammy mentioned, a customer, somebody else spills something on the floor. In that event, you have to show that the store owner knew or should have known that it was there long enough that they should have done a reasonable inspection of the premises and should have noticed it. And sometimes that's a little bit more difficult because it's hard to find every customer who was there during that time and ask them, did you see it, did you see it? Because the store owner, most of the time they're going to say, I didn't know it, nobody told me.
We talked a little about the licensee and the differences there. What is the duty owed to a licensee?
Well, the duty owed to a licensee is a little less than the duty owed to an invitee. And a common example of being a licensee is if you go to somebody's house for a dinner party or for a Christmas party, you are a licensee at that person's house. They have invited you there, and you're there for your own benefit, or going to church or something like that. The duty there is to not willfully or wantonly injure you, and to basically not expose you to hidden dangers. So it's a lot less. I can't set traps and things like that at my house. and not be responsible for it. But it's a higher bar than negligence, though. So in other words, the folks at the Walmart and the Starbucks and all that sort of thing owe you a higher duty to keep their premises reasonably safe, as opposed to if you come into my home as my guest.
Yeah, and what Tammy's saying is that's wanton. What the heck does that mean? Well, the law says that means you can't act with a reckless disregard for the safety of others. I mean, again, it's a lower burden than, say, a store owner has. But, for example, if you've got a stairwell down to your basement and the first step is the drop is like, say that, versus the rest of them, then you probably have a responsibility to tell that person and watch that first step literally.
Right.
If you don't do that, of course, you can be held responsible. I think you could be held responsible as a homeowner. But like Tammy said, in general, I agree that if somebody's at your house, you owe them a lesser degree of care than, say, a store owner does for somebody on their premises.
Actually, when we come back from this break, a question about the responsibilities of a homeowner, a specific question about that. We'll get to that after this short break. As we head to break, a reminder, time for you to get your questions to us. You can call, text, email to get them to us. Also find the firm on Facebook at Hollis, Wright & Couch. Search that term, and on Twitter at Hollis_Wright. Stay tuned. The final segment of The Attorney is coming right up.
From all of us at the law firm of Hollis, Wright & Couch, we're glad to have you here with us every Sunday night on Alabama's 13. This week we're discussing slip and fall litigation. In other words, if you suffer a fall and are injured, what should you do and what are your rights? After a fall or injury, there are certain questions that have to be asked. Where did it happen? Were you at home or at a business? How severe are your injuries? If your injuries are severe and you feel that the owner of the property is responsible for your fall, there are 3 more things you need to know. You should take photographs, including photos of your injury and the incident site showing the hazard. You should also report the incident to the owner and get a copy of any written report that's been done. And finally, you should consider consulting an attorney right after the incident so that any other evidence may be preserved if needed. Just remember, if you fell at a business, it doesn't mean that you have a case necessarily. Only certain cases are actionable. So contact an attorney to find out if you have such a case or not. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis, Wright & Couch want to help answer your questions on real issues you face in your life. Remember, a competent lawyer will respond to every question you send in. That's our pledge and our promise to you. As always, thanks for watching The Attorneys right here on Alabama's 13.
Learning a whole lot about those slips and falls. Almost out of time. Let's go right back to a question that we have here. Is there a special consideration for trespassing children?
Yes, there is. For trespassing adults, the only duty you owe them is to not intentionally hurt them. For children, there's something that's called the attractive nuisance, and what that is if a homeowner has something that is dangerous on his or her property, that a child wouldn't necessarily appreciate the danger, but it would look like something that would be attractive to them, something that would be fun. An example is maybe if you have a well on your property and it's obviously dangerous because the child could fall down in there. Well, to a 4-year-old, that's not going to be very obvious. They might think it looks fun to play on. So there is a special doctrine called attractive nuisance where if the danger is severe and it would not be that great of a burden for the homeowner to fix it so that it's not a danger, then you have a duty to do that, to cover up the well. Okay,
and also just how time sensitive in premises liability, how important is time and the timeliness of these filings and notifications?
Well, like all personal injury in Alabama, you have 2 years to file a lawsuit. And of course, pre-lawsuit, typically you need to get a lawyer just as quickly as you can if you do think that you have a legitimate claim. And a lawyer will probably tell you whether or not it is legitimate pretty quickly. Because you're going to be dealing with probably the insurance adjuster first before you file the lawsuit. And you always need to be mindful that you have 2 years in the state of Alabama for personal injury lawsuits, which includes premises liability.
And just real quick before we get to final thoughts, someone asked, is responsible if someone is hurt of their home? Does the homeowner have responsibility?
Well, they might, depending on how they're hurt. You know, again, like we talked about, you can't willfully or wantonly injure somebody who comes on your premises. You've got to mostly warn guests at your house, and we're talking about the condition of the premises. I want to make that clear. I'm not talking about serving alcohol or anything like that. You can be responsible for that, but on the condition of your home, it depends.
Right. Final thoughts for the night, Tammy?
I guess just my final thought would be that if you do feel like you have a claim, that it's very important to seek legal counsel just as soon as you can, just so that the evidence is preserved, so that the witnesses are found, so that the photos are taken. Just be sensitive of that.
Okay, Steve, real quick.
Well, the law certainly allows protections for people on any type of property, and I'll mimic what Tammy said. That's why it's important to get a hold of a lawyer. Most of them don't charge anything unless they collect for you, so it shouldn't cost you anything to talk to them.
Yeah, thanks so much, Tammy. Steve, appreciate the time. Thanks so much for being with us. That's going to do it for us. Ways that you can get in touch with the firm of Hollis, Wright & Couch right there on your screen. Call, text, email. Find them on Facebook. Search Hollis, Wright & Couch. And on Twitter, it's Hollis_Wright.